Hello, and thank you for joining us for this presentation on SB 1159, the employer reporting obligations under Labor Code Section 3212.88. Today, I'm pleased to be joined by, my colleague and friend Bill Armstrong, our senior partner, and I'm Tom Richard, the managing partner of the firm. And we're going to be talking about principally the employer obligations for reporting, not so much about claims obligations. Our focus today is on what employers are required to do under this law. You see up there on the screen email addresses for Bill and I. You can feel free to reach out to either one of us anytime if you have a particular issue you'd like us to address or you'd like to discuss about these employer obligations or anything related to COVID-19. If after the program you have questions you would like to present about this presentation or COVID-19 in general, you can also reach out to any one of our offices throughout the state of California. At each one of those offices, there is a senior attorney or partner standing by to answer those questions and get back to you. This is probably the fastest way to get your question answered. Because the email addresses will default to a backup attorney if anyone's not immediately available. If you'd like a PDF copy of this presentation, each attorney in those offices have a copy of the PDF as well, and we'll be happy to send that to you. If you're a claims adjuster watching this program, there will be a slide at the end on how to obtain claims adjuster credit for this. And I will have this slide with the email addresses for your questions also at the end of the program. First, a disclaimer, this is general information. It's not a substitute for legal advice on any subject matter. So please, if you have a specific issue that needs to be addressed, that should be presented to legal counsel. This is for educational purposes only. So SB 1159 is the somewhat notorious Presumption Bill that became law on September 17, 2020. And this bill included really three different labor code sections. Excuse me. The first of these three really enacted the executive order that the governor had signed back in May, and the other two are new presumption laws. And each of them covers a different class of employee. And what I mainly want to do is give you a quick summary of the first two, and then we're going to spend the rest of this program focusing on 3212.88 and the employer obligations. So 3212.86 is only in effect from March 19, 2020 through July 5, 2020, only for injuries that fall within that time frame. The other two laws pick up where .86 left off. 3212.87 covers principally police officers, firefighters, other peace officers, certain hospital workers and healthcare workers, including some home healthcare workers. And if you have any of those classes of employee, you're encouraged to review 3212.87. This law takes over on July 6, 2020. So right after the .86 and the executive order stop on July 5, 2020, this one kicks in.
Tom, if I might add,
Sure.
3212.87 has one interesting addition that relates to healthcare workers, and included, and a very important aspect of what's included is it does include custodians who are involved in areas where COVID patients may be taken care of, especially in a hospital setting. So while it's primarily focused on healthcare workers themselves, there is one expansion so that custodians can definitely be included under 3212.87.
And that sort of makes sense to me in well, in the context of presumptions in this for this pandemic, because they're probably going to be exposed to tissues and bed sheets and other things where COVID patients were in their from their hospital rooms, for example.
Absolutely. Agree completely.
So 3212.88, like 87, also takes covers injuries for July 6, 2020 going forward. And it is limited to California employers who have 5 or more employees, which are, I assume, quite a few employers in California. The two elements that have to be met are that the employee has to test positive within 14 days of work, 14 days of a work day, and that positive test has to occur during an outbreak of COVID-19 at the employee's specific place of employment. And of course, all of those concepts are just loaded with details, which Bill and I are going to talk about. But Bill, isn't it interesting that the outbreak is tracked to the positive test rather than the last day of work?
That's exactly right. Even though the date of injury seems to be tracked to the last date of work. So we seem to have legislation that is certainly confusing, but if we are measuring the outbreak, you're exactly right. You track it from the date of the positive test, even though if the test is positive, the law seems to say the date of injury that would govern that particular COVID claim would actually be the last date of work.
So an employee could have a last day of work, say 13 days ago, and then have been maybe on vacation or away from work, maybe working from home since then. They start to feel ill. They go for a test. They get a positive COVID-19 test within 14 days. And if, assuming the employer had an outbreak, then, but not 14 days or 13 days earlier when they were at work, they would be covered by the presumption.
Yes, as strictly reading the statute, that would appear to be correct. Absolutely. As long as the positive test occurs within 14 days of a date the person was at work, then the outbreak obligations apply, even though the individual may not have worked for several days prior to the positive COVID tests.
Okay, well, we'll leave alone whether that makes any sense, but we do know that that's what the statute says. So I think it's important to distinguish. There are two. We're going to get now into the employer reporting obligations under 3212.88 and spend most of our time talking about those. And I think the first thing to understand is that there are really two separate employer reporting obligations. The first becomes effective or starts on September 17, 2020. So that's the day that this became law. And the second employer reporting obligation is a retroactive or retrospective review for any positive COVID tests from July 6, 2020 through September 16, 2020. The data for the retrospective review is due October 17, 2020. So the employers are required to transmit that information by October 17. The data due under September 17, 2020, Bill, correct me if I'm wrong, but that's an ongoing obligation triggered anytime an employee tests positive.
That's right. And the obligation is that the reporting needs to be made within 3 business days of the employer learning or reasonably should have known of the positive COVID test.
I'm going to ask you more about that reasonably should have known, Bill, so get ready. But what happens if the employer gets it wrong? What happens if there is a what happens if the employer, for example, innocently forgets that there were 3 employees that were, sort of out of sight, out of mind, that they forgot about, who tested positive, and they forget to transmit that information as they're required to do so. What happens?
Unfortunately for the employer, there is a huge potential penalty contained within the statute. What is clear from the wording of the statute is if the failure was willful or intentional, that can result in a $10,000 penalty. That penalty is assessed against the employer only, and it is assessed for every violation. Now, every violation isn't clear, and I would expect we are going to see some regulatory enactment in the not too distant future by both the DWC and probably Cal OSHA, because it appears to me that potentially both have jurisdiction and both would have enforcement mechanisms. But when it says for each violation, I would read that to say not for each log in which there is a violation, but rather for every failure to timely and properly submit the data. So if within a 14-day period, we may have missed 10 COVID positives that needed to be included, and we failed. The employer failed to timely submit those within 3 business days. The suggestion is that the potential penalty would be $100,000.
Wow. And some of these, employers, this bill covers employers with 5 or more employees, and there are small employers with 5, 6, 10 employees who are so small they may not have an HR manager, they may not have an HR department, they may not have a risk manager. I mean, of course they won't, right? We're talking about, it could be a pizza parlor or a small, retail shop. That's a lot of it. That's a lot of penalty for a clerical error.
Absolutely, for any employer 5 or greater. I mean, for those that are larger and are already in action, 2 things become immediately obvious. The first one is that the statute is not very clear in many ways in terms of what data the employer needs to accumulate and report, and we'll certainly be talking about that. But the second aspect of it is that both prospectively and retrospectively, this is a resource-intense allocation that needs to be undertaken by the employer. And one other thing, that's appropriate to mention, is this won't be the end of the employer reporting obligations, because effective 1/1/2021 with AB 685, there will be further employer reporting obligations concerning COVID, which will accumulate to employees and others who may be within the workplace. So one can certainly see that the intent of the legislature was to, in my view, place a huge resource burden on employers who are attempting to operate from a business standpoint, and equally challenging for those who are attempting to reopen in an already significant employer burdened COVID situation. The other thing that this law 1159 makes clear is that the reporting obligation under 1159 of the employer to the claims organization is in addition to every other reporting mechanism of COVID-related tests and issues that the employer may have, including those which it may be obligated to make to the County Department of Health, to the State Department of Health, or to other administrative agencies. So an already burdened employer system becomes even more burdened with a higher degree of potential penalty allocated toward them, unfortunately, under 1159.
Well, that's some scary stuff. So let's dive in a little bit deeper about, I mentioned there were two separate reporting obligations. So let's talk about the first one. This is what I'd like to call employee tracking, and this is for effective September 17, 2020. So if we are recording this, there's already been over a week since then. So there's potentially, there's definitely going to be COVID cases out there, or I should say COVID positive tests that have occurred, and employers were already obligated to start reporting that information to their claims administrators. And in italics here, we're stressing whether or not a workers' compensation claim is made in connection with the specific test. So I think this is something that can't be said enough. This is a reporting obligation for every positive test that an employee has. Even if the employee says, I am certain I did not catch COVID-19 at work. We were all very, very, very safe at work. Unfortunately, my spouse or a loved one at home came down with COVID a week before I got tested. I was taking care of them. I was feeding them. I was doing this. I was doing that. I was doing their laundry, mopping their head, whatever. I'm certain I got it from that loved one at home. If that's what the employee tells their employer, but the employer is aware of their positive test, Bill, correct me if I'm wrong, but that has to be reported.
Yeah, absolutely. I would agree completely. The only positive test that is known or should have been known by the employer that doesn't need to be included would be for an individual who has not been at a specific place of employment. So if the individual is 100% working remotely from their home, that is the only positive COVID test that would be permitted to not be tracked and reported in this 1159 system.
And that's unusual in the workers' compensation context. And we are talking about a piece of workers' comp or purportedly workers' comp legislation, in that usually employers don't report to claims administrators when there is not a workers' compensation claim or some sort of knowledge of a workers' compensation injury. This is reporting of a test result as opposed to an actual claim.
Right, and as I know we're going to talk about, one of the further aspects to this reporting that makes it even more challenging for the employer is that it appears that the reporting of a positive test, where the test is not associated with the employee having made a claim that the test is work-related or a DWC-1 is filed, then there appear to be clear privacy components to the reporting of the positive test. And what looks like for the worker who has the positive test, but the one who you indicate says, look, I got it at home for my spouse or my child, I'm not claiming it work-related, they need to report that test, but they need to be, the employer must be extremely attentive and careful so that they do not create a privacy invasion risk in the reporting of that data to the carrier or claim administrator.
Because that person is not a workers' compensation claimant.
That's right.
Where they don't necessarily have that full privacy right once they file a workers' comp claim, and the employer is certainly free and obligated to communicate that person's name and the nature of the injury as much as they know of it, to the claims administrator. But as this slide says, under this law, if the employer knows or reasonably should know that an employee has tested positive, the employer is required, as you said, within 3 business days of suspecting that an employee has tested positive, the written notification, which we will cover, and that notification shall not provide any personally identifiable information regarding the employee who has tested positive for COVID-19 unless the employee asserts that the infection was work-related or has filed a claim form. So, Bill, I'm going to throw a couple of balls at you right now. One is, what does it mean when an employer suspecting that an employee has tested positive? And what does it mean if an employee asserts that an infection is work-related but doesn't actually file a claim form?
Well, the way I'm seeing the reporting of information to the employer, it's coming in a myriad of different ways. At times, they might get a notification from a physician that the individual needs to be off work for a period of 14 days. They may get a request from the employee for a medical leave for a period of 14 days. There may actually be reporting that comes in through the county that might notify the employer of a possible positive test. So what we don't know is who at the employer is responsible for assimilating all of this information that might be coming in from the employee, from a physician, from a leave carrier, that third-party administrator that many employers have, or that might come in through a county. So one of the things that's going to be prudent and probably important for every employer is to ensure that all of those who receive input on positive COVID tests for employees, and usually those are associated with the employee being quarantined and taken off of work for 14 days, that needs to be assimilated to those who have the responsibility for the 1159 accounting and accumulation of data to the employer or to the carrier, and failure to do so can definitely result in the 1159 penalty. And then we get into reasonably suspects. I mean, I would think that is going to place the employer, many employers, in the position of almost being a physician. But certainly if we were to get information from the employee that they need to be off of work for a period of 14 days, I think that would be enough to trigger for the prudent employer information in today's medical climate to suggest that there could well be a positive COVID test, and to take appropriate actions, if any, to determine if there has been a test and if it has been positive, as opposed to an individual who's taking time off because they have flu-like symptoms or other symptoms that could mimic a COVID infection but are truly not documented by a test. But needless to say, it puts the employer into a position of needing to have significant knowledge to appreciate when there may be adequate information for the employer to understand that there may be information that a reasonable employer would know of a positive test.
And so if an employee were to call in and say, hey, I'm not coming in today, I'm not feeling very good, cough, cough, I have a dry cough and a fever, and I've suddenly lost the ability to taste or smell. I don't know what's going on, but I just feel like I shouldn't go in today. Is that enough to suspect an employee has tested positive? Or, I mean, he didn't say anything, the employee didn't say anything about a test.
Right.
But I'm not sure what an employer needs to do with that information.
Yeah, that's a challenging one, because the loss of smell or taste is a known distinguishing feature of COVID-19 from the flu. So to me, that could definitely trigger awareness of the employer that a COVID condition might exist. But on the other hand, the triggering mechanism, as you've mentioned earlier, isn't the diagnosis or even the suspicion of the condition, the triggering of the reporting is the positive test. So it probably would be prudent for an employer to attempt to understand in working with their employee whether there has been any tests. Is the employee, how long of a leave might they be requesting, and are they under the care of any follow-up physician? And this would especially be in terms of larger employers are probably going to have some advantages here because they can outsource to administrators the leave administration, and more appropriate questioning that doesn't run afoul of privacy could be undertaken in that way. But for the employer that doesn't have the breadth of having a leave administrator, then the question of how does the employer determine if there has been or not been a positive test, I think they would need to be very careful in terms of how they approach that. But ultimately, they are going to need to know from the employee, have they been tested, and to make a request of the employee to provide the test if the results are available.
And under that hypothetical, if the employee called in on a Monday and with these symptoms, and maybe the employer asked, have you been tested? And if you do get tested, please let me know. And the employee calls back on Wednesday and says, lo and behold, I did get tested and I am positive. I got tested today and the test was positive for COVID-19. The 3-day reporting obligation runs from Wednesday, the date the employer knew of the positive test, not from Monday when the employer first suspected an infection. It's when the employer first suspected the positive test. Right?
Absolutely right. Yes.
Okay.
Yes.
And that's, I think, a good practical takeaway, I think, for the employer, as is the this written notification requirement that cannot identify the employee. And I've had some employers I've been talking to have come up with a system of using a number, like a sort of a randomized number, so that anytime they get a positive test, they assign a number and they internally use that number to keep track of who that applies to, which employee. And they only provide that randomized number to the claims adjuster. I'm sure there are other ways of doing it, but that's this personally identifiable information element is that also presents challenges.
Right. And one of the things I think is important to emphasize here, Tom, is that the apparent privacy right applies to transmission of the information from the employer to the claims administrator or insurance company. If the employer has established procedures within their organization, which is known to the employee, where the employee's name might be used, for instance, in a communication between benefits, risk management, and human resources, in understanding whether there's been a positive COVID test, there's nothing in the statute that impacts the employer from being able to use the name of the individual internally to collect the information that it might need, provided the employer has already taken all appropriate steps to ensure that perhaps there's an employee release on file or some notification to the employee that when they provide the positive COVID test, it can be utilized for limited purposes. So the employer can use the name of the individual internally. The preclusion is attaching the name in the report that goes to the claim administrator or insurance company.
Got it. Okay. One thing is clear is what test, when we say test or testing, the statute thankfully is clear in that respect. We are talking here about the PCR test, which they identified, or any other test approved for either regular or emergency use by the FDA. to detect the presence of viral RNA. What was specifically excluded from the definition of test or testing is serologic testing, also known as antibody testing, which remains acceptable for verification of a diagnosis of COVID-19 only for injuries before July 6, 2020. That's pursuant to the original executive order and Labor Code section 3212.86. But for the section we're really focusing on today, 3212.88, it has to be an actual PCR test. It cannot be an antibody test. That will not suffice as the test that triggers this reporting obligation and potentially triggers the presumption.
And usually when the employer or when the employee provides a copy of the test, or the employer gets it through some other appropriate and lawful mechanism, the test itself will usually identify the type of test that was done, so that the employer doesn't need to go become a medical researcher. It will usually identify if indeed it was a PCR test.
And I think I'm not sure if we mentioned this before, but the date of the test is also defined in the statute, thankfully, as the date the specimen was collected for testing. I think there probably is less lag time than there used to be, but sometimes the lag time between the actual, sitting down and having the test and getting the results of that test could, used to be a matter of days. Now we know, so we weren't sure which date to use. Now we know it's the day the testing is collected.
Right. So for the employer, they have, again, a bit of a challenge here, but the date of the test is of the positive test must be within 14 days of work, but the date of the employer 3-day business obligation to provide it to the claims agency is the date they become aware of the test.
That's right. And that could be days or even a week later where they become aware of it.
That's right.
That's when their 3 days starts. That's when the employer's 3 days starts.
That's right.
Okay. So the employer has an ongoing reporting obligation of this information to the claims adjuster. And this obligation includes a written report or written notification to the claims adjuster to include the specific address or addresses of the positive test to the employee's specific place or places of employment during the 14-day period preceding the date of the employee's positive test. So this is the 14 days prior to the positive test, not 14 days prior to the employer becoming aware of the positive test, which triggers the 3-day obligation to report. Now we're going back to that test date, that positive test date. We're looking backwards in time 14 days. Every specific place of employment, which is very well defined in the next couple of slides. You look 14 days backwards in time from that positive test date, and you identify each specific place where that employee has worked. So that's the first thing you're looking for. The second thing the employer wants to do is report the highest number of employees who have reported to work at each of those job sites. Now that you've identified the relevant job sites, at each one of those job sites, what's the highest number of employees who have reported to work there in the 45 days preceding the last day of that the employee worked there. So these are, two separate time frames triggered by two separate events. The first part is what address is a 14-day period going backwards from the positive test date. And the other one, the 45-day period preceding the last day of work, is a separate. You're starting from two separate days and you're running two different time frames.
That's right. Yeah.
And
two different collection pieces of information.
Right.
Within 14 days, you identify every place the employee worked for you, and then and then you have to go back. And again, this needs to be done within 3 business days of learning of the positive COVID test. You then need to identify the highest number of employees who reported to each job site in the 45 days preceding the last day the infected employee worked at those locations.
And I don't think I don't think it's I think we should say we're not actually transmitting people's names. The employer is not actually transmitting people's names. The employer, I mean, assuming the employee has not asserted that this is work related or made a workers' comp claim, we're saying, you know, we're identifying there was an employee who tested positive, and he worked at, or she worked at 123 Main Street, 567 Brown Street, whatever, these addresses of our locations within the 14 days before that test. And with regard to those two locations, here's the number, not names, but number of employees who worked at each of those locations in the 45 days preceding that employee's last day of work there, the total number.
Right.
That's a lot of data.
That is a lot of data that needs to go within 3 business days of learning of the positive test, for sure.
So that's the first reporting obligation, and that's an ongoing obligation. Anytime there's a positive test after September 17, or on or after September 17, 2020. But the employer has another obligation, as if they didn't have enough to do, another obligation that becomes due no later than October 17, 2020, and that is to conduct a retrospective review of past positive tests and report those to the claims examiner. And the reason we have this separate time frame is because, as I mentioned earlier, this law is effective July 6, 2020, but it didn't get signed by the governor until September 17. So there was this window of time between July 6 and September 17 when the prospective or forward-looking reporting wasn't happening. So what the legislature has done is give the employer the additional obligation of now looking backwards in time and providing this retrospective review to the claims examiner. And as with this, has to be reported to the claims adjuster in writing, and it can be by electronic mail or facsimile, but it has to be in writing. This cannot be done by phone call. The retrospective review, it will sound somewhat similar to the other review in that it provides the specific address or addresses where the employees, where that positive tested employee worked during the 14 days preceding the date of the employee's positive test. That sounds familiar. And the employer also has to report the highest number of employees who reported to work on any given day between July 6, 2020 and September 17, 2020 at each of those specific job sites. And for those of you paying attention to the italics, this is a different measure than in the forward-looking reporting, right, Bill?
Exactly. That for reasons that aren't clear, but which are clear from the statutory reading, it doesn't jump off the page with the first reading, the second reading, and the third reading. But Tom indeed did discover when you go through the portion of the law
Oh, Bill, I think I lost your audio.
clear on retrospective review, they make that there is a administrator. And so what is different is that for the retrospective, the employer is required to list the highest number of employees who reported to work, quote, on any given workday, close quote, language, which is not included in what the employer provides prospectively for positive COVIDs on or after 9/17/20.
So prospectively, we're looking for the total number of employees in that 45-day time frame. And for retrospective review, we're looking for the highest number on any given day between July 6, 2020 and September 17, 2020.
Absolutely, that's absolutely correct.
And what if, Bill, what if between, let's say on August 1st, 2020, this place where the employee worked for most of the time, let's keep it one job site, Generally, that place has maybe a handful of employees that work there on any given day. Maybe it's a big warehouse or a big space, but just few people who work there. But maybe there was a day on August 1st, 2020, where for whatever reason, and employees came in from other facilities. They were all social distance, right? So they were all standing more than 6 feet apart and wearing their masks and using hand sanitizer. But they came there because there was, I don't know, some kind of meeting that had to be done in person or some kind of training. Maybe it was a COVID training, right, on how to go out in the field and be safe and not get COVID yourself or spread it. And maybe on that particular day, there were 50 employees on just one day who were there for a half an hour meeting. Does that mean that the employer is reporting the average, which is maybe 5 or 6 people a day, or are they reporting 50, which happened to happen for one brief half hour on one day in that entire time frame?
Well, the way I envision this reporting to look like, Tom, and I mean it may well differ from employer to employer in the requirements of the claim administrator, but the way I envision the reporting occurs is the employer lists the number of employees on each of the days within the 45 days, the number of employees who are at the work location on each of the days within the 45 days. And so for that one day in August, when there may have been 50 in a work, even though 40 of them were only there for a half an hour, 15 minutes, 10 minutes for a meeting, they would be required under this statute, in the clear wording of the statute, to report the 50 that were there, even though they were there for only a very short period of time on one single day.
Okay, so this is just a recap. We're looking at 2 different employer reporting criteria for post 9/17/20 going forward. Any positive test, your employer is reporting the highest number of employees who reported to work at that place of employment in the 45 days preceding the last day the employee worked there. So that's the total of employees. And then for, on any given day, that this is, I think there's an, yes. And for what that means is the employer adds up all of those positive tests within that 45-day time frame. And then the second one is pre 9/17/2020 for the tests from July 6 through July 17. The employer is instead reporting the highest number of employees on any given workday between July 6 and September 17, which is the effective date of the statute. So 2 different criteria, 2 different reporting criteria that the legislature established for employers.
And while I don't think it is risk-free, if on the retrospective assessment, if the employer were just to report in writing within the 3 business days, the one specific day where there was the highest, it appears that an argument could be made that that's sufficient. In other words, it appears that retrospectively, they may not be required to report the number who reported to work at each specific place of employment each workday between July 6th and September 17th, so long as they provide the day when the highest number of employees were there and provide the highest number of employees. But I'm not confident that that approach is risk-free in terms of the employer reporting, and it does vary distinctly from the reporting from and after 9/17/20. So being as conservative as I am in trying to protect employers and our clients, especially in terms of accumulation of this data, I think it's extremely important probably to report total head count by day between July 6th and September 17 for that 45-day period, and make sure we include in there the highest number that was there on, quote, any given day within that 45-day period.
Wow. I do not envy the people accumulating this data. So let's ask, what is a specific place of employment? As this is, this is the place we're going to be looking to track all this data. The legislature provided some explanation of what they meant by this term, specific place of employment. The legislature said building, store, facility, or agricultural field where the employee performs work at the employer's direction. If the employee works at multiple locations, then the presumption would apply if an outbreak exists at any one of those locations. So if an employee works at 3 different yards or buildings, and there's an outbreak, what's later determined to be an outbreak at any one of them, then the presumption applies to that employee, or and all employees who went into that building or worked out of that building within that time frame. And if the employee's positive test, if the employee does have a positive test and does work at 3 different buildings, that test is counted for purposes of determining the existence of an outbreak at all 3 of those places of employment. So each place, the employee gets counted over and over again in determining whether there's been an outbreak, because he or she gets reported for each specific place of employment. And I think it's just how do we drill down a little bit further into what are we talking about for this specific place of employment? I think it's interesting that the legislature said building as opposed to campus. So for example, if there's a large, like a Silicon Valley employer with a campus and a dozen buildings on that campus, my reading of this is that this is referring to a specific building on that campus, not the entire campus. Similarly, if there's a retail store with 100, a retail employer with 100 retail stores in California, this is referring to an individual store as opposed to their entire California operation. Similar with agricultural field. So it's somewhat specific, but I've also had employers who have different kinds of operations where they may have employees report to a broken water main in the case of a utility district, for example. And maybe there's 5 or 6 employees gathered around they go from home to this job site every day for a week to repair a water main. They're not actually going inside of a building or a store, or it's not even the employer's facility, and it's certainly not an agricultural field. But is that spot on the street, which is the employer has no control over other than the right to do repair work, does that count as a specific place of employment? Are we tracking? Is the employer then obligated to track that information for all the employees who reported to that one job site?
And one thing that is unfortunate is that the law didn't give any definitions as to what the legislature intended by the meaning of, quote, building, store, facility, or agricultural field. So I think there is a fair degree of interpretation, but hypothetically, let's assume a store, let's assume an employer has a 5-story department store, and they have employees who are permanently assigned to each floor. Does the employer only count the employees on the floor where the positive COVID test occurred, or do they count all of the employees who enter that store, even though they may be working on the 5th floor and the positive COVID test was on the 1st floor? My interpretation would be that it's every employee who entered the store would be counted, not just the employees who are on the floor where the worker with the positive COVID test occurred. On the other hand, if we were taking agricultural field, let's assume that in an agricultural field, an employer is doing farming in one area, picking in another area, packing in another area, and shipping in a 4th area. Does the fact that there may be 4 different functions within an agricultural field mean that the employer has to count them separately for each work location within the field, or do they count the total number of employees who pass through the gates to enter the agricultural field? And my interpretation, in the fact that there is no additional definitional criteria within the statute, and using the analogy to the store, is the employer would count everybody who enters through the gate into the agricultural field, even though they may be performing different functions in different locations once they are inside the field.
Another way that there was some explanation is that, as Bill mentioned earlier, the employee's home or residence is specifically excluded as a specific place of employment. So we know that none of the employees who have been working from home this entire time are part of this data census or part of this presumption. But again, this is for people who have exclusively worked from home or from their own residence, not folks who have, may be going into the office one day a week or one day every other week, or even, once or twice during this entire pandemic. They may be covered depending on how the timing runs. And an exception to this exception is that if the individual is a home health care services provider and they are caring for an individual within the employee's own home or residence, then their home or residence does become a specific place of employment for purposes of this statute.
And one other add to that, Tom, is overlapping some of this for some employers is going to be the 321287 aspects that you mentioned earlier. Even though you may have employees there, such as public safety officers, firefighters, or others, who would be covered for the presumption under 321287, if such an individual had a positive COVID test, but what we were determining, or what we were doing from the employer standpoint, was submitting data for an individual who isn't covered under the presumption of 321287, we would need to include the employee population of those who are covered under the presumption of 321287 in the employee data, even though those individuals would be covered under 321287 for a different presumption. So employees who are covered by a presumption are still included in the reporting data under 321288 in assessing a COVID test for an individual within that work location where that worker is not covered by the presumption.
So what happens with this data once the employer accumulates this data and they transmit it to their claims adjuster? What then happens? We're not going to spend too much time talking about the claims adjuster role. We've covered that elsewhere. There's another, by the way, another webinar which RTGR has on our website that goes into greater detail regarding the presumption itself and its legal effect, and how to rebut the presumption, specifically what the claims adjuster can do to investigate and rebut that presumption legally if it applies. So there is that data is available on our website for an earlier webinar if you care to watch that. But where we want to really focus on is for the employer to understand what's happening with this data once it's transmitted to the claims examiner. So then for this information, first of all, the employer's reporting this to the claims adjuster on a rolling and continuous basis. So every time there's a positive test, the employer's reporting a new set of data to the claims adjuster. Meanwhile, the claims adjuster on their end is on a rolling and continuous basis, looking at this incoming data and making a determination at each instance whether there's been an outbreak. And an outbreak exists if within 14 calendar days of within a 14-day time frame, one of the following occurs at a specific place of employment. So one is that an employer who has 100 or fewer employees at a specific place of employment. If 4 of those employees test positive for COVID-19, that means there's an outbreak. So we're not talking about employers who have 100 or fewer employees necessarily. We're talking about employers who have 100 or fewer at a specific place of employment. So this could be an employer with 1,000 employees, and in one outlying facility that the employer manages, this is particularly true for public agencies that may have a far reach of facilities throughout the county, for example, and maybe there's a maintenance yard fairly remote from a big city. Maybe there's a handful of people or a dozen people who work there. Even though the employer may have 2,000 county employees, but only a dozen that report to work at that maintenance yard, then what the adjuster is going to be looking at is 100 or fewer employees at that specific place of employment. So that they're only going to looking at the fact that there's a dozen people there or a dozen people there, not the thousands of people that work for the county altogether. The second way an outbreak is defined is if there's 100 or more employees at a specific place of employment. So now we're talking about a fairly large operation in one spot. Then if 4% of the employees who reported then that triggers an outbreak. The third is if there's at a specific place of employment, that facility, that store, that building, that agricultural field are ordered closed by a local public health department, the State Department of Public Health, the OSHA, or a school superintendent closes the facility because of risk of COVID infection, not because that the school district is required to do it, because of just generally all the schools are closed, but if the school or that location is closed specifically because of a risk of COVID infection. So that's how an outbreak is defined. The claims adjuster is given the unenviable job of using this information to determine if an outbreak has occurred, and then applying the presumption to that situation. The adjuster must review every positive test and determine if there were 4 or more, or 4% or more positive tests at that specific location within 14 calendar days. If the adjuster concludes that an outbreak has occurred, the presumption would apply, and the adjuster has to continually evaluate each claim to determine whether the requisite number of positive tests have occurred during the surrounding 14 days. And Bill, this is, I know, something that you've brought to folks' attention. We're talking about 14 days surrounding the date of injury. So does that include, that's not just limited to the 14 days preceding the test?
That's exactly right. I think the 14 days can be a trap for the unwary. It's actually, if we were to look at it, and because the requirement is that it be reviewed on a rolling basis, it's actually a period of 28 days. So it's 14 days before the positive test. And again, the adjuster would need to look at it 14 days after the positive test and look retrospectively and make a determination as to whether there were 4 or 4% or more, whichever criteria is required within that 28-day period, 14 days before the positive COVID test and 14 days after the positive COVID test, so that before they could ultimately determine an outbreak did not occur on the 14th day after the positive COVID test, they will need to do the outbreak analysis.
And rule it out for that.
Exactly right.
Yeah.
Exactly.
As I said, unenviable. Okay, what else? So what else should employers do now that we know this? Is there anything else besides all of this reporting obligation? I think it doesn't hurt to remind everyone that it's a good idea to put in remedial measures. In fact, I think it's required that employers have remedial measures to protect their employees and the public from the spread of this disease. But those remedial measures, in addition to being good for public health and good for society, now have the added benefit of being specifically identified in this statute as a means of rebutting this presumption. So we included this slide here because this is I think very relevant to employers. So if you have in place remedial measures, you've got written policies and waivers and postings all throughout your facilities, advising employers to, requiring employees to wear masks, to keep their social distance, to wipe down surface areas, to do all of those things that we've all become very familiar with. Documenting the fact that you have those things in place is an affirmatively identified means of workers' compensation folks being able to rebut these presumptions. And that makes, at least this part of the bill makes logical sense to me, because if an employer is keeping their workplace very safe and an employee tests positive, and even if the workplace is very safe, people get COVID-19. If it didn't happen, we wouldn't be in a pandemic. So people get COVID-19, and maybe all the employees who got it outside of work. In the case of a particular employer, but maybe the numbers are such that an outbreak is actually determined to have occurred, and maybe one or more of those folks' positive tests result in a workers' comp claim, and that claim is now covered by the presumption and presumed compensable. The fact that the employer had these remedial measures and can prove it, that means it's documented, will help the adjuster and the defense attorneys like Bill and I rebut this presumption and prevail in that workers' compensation case, especially in cases where it's pretty clear that the infection occurred outside of work.
One of the other aspects to that, Tom, and why I think your guidance of making sure that all appropriate remedial measures are introduced by the employer, accompanied by documentation and especially employee training, is we are already seeing, in a certain sense, a unfortunate pandemic in more serious COVID illnesses, of efforts by plaintiffs' attorneys to try to get the employer outside of exclusive remedy. While I think it's highly unlikely that the efforts to sue the employer in tort for more serious positive COVID illnesses that are work-related and which may have arguably occurred in circumstances where the employer did not have appropriate remedial measures in place, I do think that the fallback position is serious and willful misconduct. So I think it's incumbent, in addition to doing the reporting correctly, that the employer have appropriate training and all remedial measures and have that documentation in existence, because absence of that not only will mitigate the ability to rebut the presumption, it may increase the risk of serious and willful misconduct liability under the Labor Code.
And serious and willful misconduct liability lies with the employer. Even an insured employer is responsible for the costs of serious and willful misconduct claims.
Right, and incorporates 50% of the cost of the medical treatment. So any individual who's hospitalized with a ventilator, we can anticipate the cost of that medical treatment would be rather substantial. And one of every $2 that is spent by the claims administrator in those more serious cases would be the potential risk for the employer, which cannot be covered by insurance.
So pretty good reasons to keep track of this data. Just briefly mentioning the benefits under the presumption, especially those that tie in carefully with employer benefits outside of workers' compensation. The SB 1159 expands and places limits on workers' compensation benefits that don't exist outside of this particular law. One of them is a sick leave offset. So if the employer has paid sick leave benefits specifically available in response to COVID-19, then those benefits shall be used and exhausted before any temporary disability or other Labor Code Section 4850 pay, for example. Other benefits are paid, normal workers' compensation benefits are paid. And this is not sick leave that the employee has accumulated in their sick leave bank, not vacation pay. We're talking, this is specifically available benefits, leave benefits in response to COVID-19. There were several employers that offered that benefit. There's federal and state benefits that kick in. Those have to be offset first, or exhausted first, before the temporary disability or 4850 benefits kick in. Bill mentioned third-party liability and the exclusive remedy rule as an issue here, where employees are trying to, our plaintiffs' attorneys are trying to creatively use COVID-19 as a tool to get around the workers' compensation exclusive remedy and sue employers directly for, let's, hypothetically unsafe workplaces and so on. So hopefully they won't prevail in that, and the exclusive remedy rule will hold up. But what about liability to third parties? If these laws create a presumption of injury, which wouldn't otherwise exist, and the employee then exposes members of the public or members of their household to the disease, which is presumed to have been caused by work, does that create liabilities traceable back to the employer by those third parties who are not necessarily barred by the exclusive remedy rule, especially if they're not a member of the employer's family, the employee's family? That's something that may come to pass, hopefully not, but I'm not sure if it was an intended or unintended consequences of this law.
Well, I think it becomes an enhanced risk for employers, especially after 1/1/21, Tom, with the enactment of Senate Bill 685, or I'm sorry, Assembly Bill 685, because that bill, effective 1/1/21, will require a notice from every employer to each employee anytime the employer has reason to believe that the employee has worked in an area where a potential COVID exposure occurred. And what the employer notice is, it's required to be in writing. It's required to be given within 1 business day. It's required to notify the employee. It also expands it beyond employees, but I'm just using employees here as an illustration. It requires the employee to be notified of the fact they may have had a potential exposure. It requires the employer to notify the employee of all of their potential rights and available benefits under various laws, including workers' compensation. And lastly, it's going to require the employer to tell each of those notified employees of the steps the employer is going to take to ensure the workplace is safe, including cleaning, etc. So my view is that is going to create a statutory duty to the employee, and if the employer breaches that and that other employee then develops a COVID infection and takes it home, I think the potential third-party risks are enhanced.
And so that's a perfect segue for me to mention that for those of you listening to this webinar before October 13th, Bill will be talking more about AB 685, which I want to emphasize doesn't take effect until January 1, 2021. So everything we've talked about today is already the law, SB 1159. AB 685 takes effect on January 1st. Of course, that's pretty close. It's already almost October as we record this this webinar. So employers, of course, need to start planning for AB 685 now. And Bill will be talking more about that at the California Self-Insurers Association webinar on October 13, 2020. So if you are interested in learning more, you can research or just look at the CSIA website and register for Bill's program, which will cover some of what we've talked about today on SB 1159, but also go into further detail on AB 685. I also suspect that we'll do another one of these, perhaps after the CSIA program, where we will go into more detail about AB 685 and preparing for 685. In just a moment, I'm gonna ask Bill some questions that we've gotten in from folks about SB 1159 in preparation for this webinar. But if you're a claims adjuster listening to this program and you would like continuing education credit, you can send an email to your nearest RTGR Law office, and we are happy to send you that certificate of attendance. So you can email your nearest office, and I'll show you those email addresses again in a moment. Questions, to request a PDF of this slide, and to get your workers' compensation adjuster continuing education credit. We keep a ongoing and updated COVID-19 and SB 1159 and everything else that's going on blog post on our website, rtgrlaw.com. You can go there for more information. And if we also post, anytime we do an update, we will put it on our LinkedIn page and on our Twitter page. You can connect with us on LinkedIn or follow us on Twitter and not miss out on updates as more information rolls out. Our firm, just very briefly, Bill and I have been all over COVID-19 related issues and this law and this executive order before it since the very beginning. It's mainly because of the clients that we have and the tough questions that they ask. And for us, it's been par for the course because we are I think, well adapted at dealing with the most challenging claims and controversies. So if it's a tough job, then our firm is always on top of it, and it's really sort of part of our DNA to focus on the more challenging aspects of workers' compensation law, civil subrogation, and especially where employment law overlaps with these things and creates multiple issues and liabilities that we want to help protect our clients from. So let's get on to some questions. Again, here are the email addresses to send your further questions, request a PDF of the PowerPoint. So Bill, let's say that there are employees, we're an employer, we have employees of a vendor who come to our office building and are doing work for a period of time. And we found out from that vendor that 3 or 4 of those of that vendor's employees, while at our building, during that time frame when they were working at our building or our location doing their work, they tested positive for COVID-19. Do we include them in the head count for reporting on this information to claims adjusters?
Assuming that the vendor is truly a third-party independent contractor without any argument that they would be a potential dual employee or general special employee under the SG Borello and or AB5 requirements that are now in place effective July 1, 2020 to determine employment. But assuming it's truly an office building and we call an HVAC contractor to come in because in our 100-degree weather we've got an air conditioning issue and those individuals come into our work location, do we count those individuals? No, we only count employees. So if they're truly independent contractors, then we would not count those individuals in our head count for reporting to the claims administrator either prospectively or retrospectively. And if we learned of any one of those individuals who developed a positive COVID test, those would not be included in any of our counting and data accumulation and reporting to our claim administrator.
Same would probably be true, will definitely be true of customers who come into your store, right, or members of the public who come to file documents, or none of those folks would be counted as well.
Exactly right. I would agree with that 100%.
What about, okay, so what about contingent workers or temporary workers who, maybe you call a temp agency because you need, something filled, and that there's a temp worker who is employed by a different company, but has been working for you now for several and develops COVID. Does their positive test result that you come to learn about, Does that count it?
Well, one thing becomes clear under SB 1159 is the legislature appears not to have a good understanding of the modern California workforce. So all the statute says is employee, and it doesn't define who would be an employee in this circumstance of temporary agency individuals who come into our workplace and or what many of my clients call contingent workers. I have analyzed this a lot. My perspective is that each employer is going to need to analyze this issue globally and have it analyzed by their preferably very skilled legal attorneys to analyze the overall implications, because 1159, to my way of thinking, would require an employer who has a general special employment relationship, which generally would be a temporary agency, or a dual employment relationship, which could certainly arise in contingent workforce, and especially with AB 5, so that in effect we have two workers sitting side by side. One comes from a temporary agency and one is hired by the employer, and they're doing exactly the same work using exactly the same employer equipment and methodologies. They're working under the supervision of the same supervisor of the employer, and they work the same hours and at the direction and control of the employer. I have to think that those individuals, for purposes of this law, would be considered the employee of the employer, even though they're on the payroll of a temporary agency or a contingent workforce entity. So my view is that there is a serious risk that we do need to consider including those in our data accumulation, data reporting, and for positive COVID tests, the reporting and inclusion of that test of a temporary agency employee who is working side by side with one of our own workers. Now, over many, many years, I've managed these types of issues, and I fully understand that there are more global business issues for employers and our clients well beyond workers' compensation, and that oftentimes the contract with the temporary agency or the contingent workforce entity will describe these workers as being independent contractors, and there can be many reasons for that, including benefit reasons, stock option reasons, leave reasons, staffing issues, and all of those. And my view is that every employer is going to need to analyze this entire issue anew and more globally to see if they will continue to assert that these individuals working side by side with our own employees doing exactly the same work, are we still going to categorize them as independent contractors because of our historical global perspective? And if we do that, are we willing to undertake the risk that that is not a correct judgment in light of the 1159 $10,000 per violation issue for failure to submit an accurate log, accumulate an accurate log and submit it to the claim administrator for outbreak purposes? So I don't think there's necessarily one right answer, but I do think it's incumbent upon every employer who uses temporary agency employees and contingent workforce employees to reanalyze this entire business issue with their corporate legal attorneys and other attorneys and internal personnel, now recognizing the potential for a $10,000 per violation risk if we do not classify these people as our employees, and ultimately we are found to be incorrect in that determination.
Okay, we have just a few more minutes left. Here's one. This question has come up again and again from our hospital clients and our public safety, public agency clients who have public safety workers. if you have an employee or you have a group of employees that are definitely covered by 3212.87, so they're police officers, firefighters, hospital custodians, certain healthcare workers, and so on and so forth, you know they're covered by 3287 in that statute, which is, by the way, relatively easy to implement compared to 3212.88. Let's say your hospital has, or your facility has 100 people working there, 75 of them are covered by 3212.87, but you also have a bunch of folks who aren't covered by 3212.87, like maybe the person who works, people who work in the cafeteria and people who do records keeping and things like that, but they all work in the same building. Do you count just the 25 folks who do not fall under 3212.87 in your 3212.88 reporting census, or do you count all 100, including the folks that are already covered by another presumption?
My analysis of the statutes is you would include all 100. So even though the individual worker, if they acquired a COVID infection, would be covered under a 3212.87 presumption, in analyzing whether a non-3212.87 individual might have a COVID infection covered by a outbreak presumption, you would include the entire population of those who are specifically covered under 3212.87.
Okay, I'm going to do 3 quick softballs. I'll answer them myself, and then I'm going to leave. We're going to conclude with one more hardball coming at you, Bill. So one easy one is, do we include employees who are on leave or vacation during the 14 days of the head count? And the answer is no, they were away from the workplace. Do we need to include a positive test for an employee who solely works from home? No, only employees who report to work at a specific place of employment. Third one, is there a minimum duration of time that an employee needs to work or needs to spend at a specific place of employment for it to be reportable? Even if they just pop their head in and say, "Hey Joe, are you in here for 3 seconds," and then leave, does that count as being in that location? And I'd say the answer is yes, under this statute, that there's no minimum time duration under the statute. So they would be counted if they set foot in that specific place of location, specific place of employment. Okay, final question on specific place of employment for you, Bill. Does specific place of employment include the facility or location owned or operated by a third party where the employer dispatches employees to do their work?
I think there are some circumstances where the answer to that would be yes. So for instance, if we have a delivery person who makes deliveries to 25 different grocery stores, or a UPS driver who might make deliveries to 25 different locations, commercial locations, not residential locations, but might make deliveries to 25 different commercial locations, then I think those individuals, in general, those other buildings or locations are likely to be specific places of employment. But if we send a worker to the grocery store or to the Ace Hardware store, to buy some cleaning solution, disinfecting solution to protect our employees,
Or
then
just pick up lunch.
Then I think the answer to that is no. So I think there's no necessarily one right answer. It depends upon the nature of the work, the nature of the worker, and the reason for the assignment that they were made to a specific location.
Well, Bill, that's why we give you all the hard questions. I want to thank Bill for his time today. This has been just a whole bunch of information. I think we've done our best to compile it for you. If you have more questions, and of course you will, here are the email addresses to send them. If you send them to your closest office, they will go to a senior attorney there who will do his or her best to answer that question. And if they will almost certainly be reaching out to Bill and I as well, or maybe Bill and I will be picking up these initially. We roundtable this within the firm quite frequently, so we will get back to you with an answer and provide you with our best analysis and keep you updated as this law continues to develop and be interpreted. Thank you, Bill.
Thanks, Tom. Wonderful job.
take care, everybody, and stay safe, and best to you and your families.